Welcome to the Virtual Center for the Study of the Constitution and Civic Responsibility, an ongoing inquiry into American political origins and evolving institutions. The Executive Director of the Virtual Center is Dr. Bill O'Brien. He is also your host for this continuing conversation. Here he is now, Dr. Bill O'Brien.
Thank you, Bob Kincaid. I kind of preempted you there. I apologize. This is Bill O'Brien, and we are here for an abbreviated version today of the Virtual Center for the Study of the U.S. Constitution and Civic Responsibility. We are starting 1 hour later than we usually do. Most days, we're starting 1/2 hour later than we do on most Tuesdays. In the East, it is 2 p.m. The top of the hour. We will have 1 hour of programming today and our regular 2-hour segment at the Virtual Center tomorrow. I want to thank you for joining us today on this, the 6th day of January. It is a Tuesday, it is cold, and it is getting colder. And I can say that advisedly because it looks like by the time we get to tomorrow, I think the best part of the entire nation is going to be covered by, is going to be feeling this cold, so-called clipper from the north. So I think my advice at this point would be to encourage everybody to stay warm, be careful, and this is really important. Check in on those people who might perhaps need some checking in on. If you have neighbors, if you have friends, if you have people in your communities who are elderly, it would be a great time to just check on them, say hello, and just make sure that they're okay. Because this will be relatively brief as time goes, but apparently it's going to be quite severe. So again, I hope all of you will take it easy. We'll get through this. I really do believe we would. I was just at a Rotary meeting, and a couple of friends were talking about this particular issue and the fact that the severity of the next couple of days seems almost to be a creation of the meteorological group, the Weather Channel and its offshoots. We have become so sophisticated in our ability to track weather and to predict weather that it seems like we are making a much bigger deal out of weather events than we ever did before. One of the people at our table today made the comment and said, "My heaven, it's winter. It's early January. We're in the mountains. This has been going on for a long time." And but I agree, because I feel it affecting myself. The more I watch the weather and the more knowledgeable I become about it, the more taken I am with the events associated with the weather. And so therefore the storms seem to be a little bit more severe, the winds seem to be a little bit more stronger, the rain seems to be a little bit heavier, the drought seems to be a little bit drier, and on and on and on. But I think I'm probably one of many on that. So just be careful, but the key part is keep an eye on those who might need a little bit of help to get them through this time. Make sure they've got heat, make sure their power's on, and if it isn't, then by all means act accordingly. Welcome to the Virtual Center on this very, very cold Tuesday in January in the year 2015. It is a pleasure to be with you. I welcome you. I look forward to hearing from you. Our topic has been the Article 3 of the Constitution of the United States, the establishment and structure of the Judicial Branch of government. We will continue that today and most likely tomorrow as well. And it's a little bit, in some ways it's a little bit dry, but on the other hand, I'm hoping with the kind of background, the kind of historical context that we've created, I know in my own case, I have read the Constitution years and years ago. I read the judicial provisions of the Constitution years and years ago. But I'll be very honest with you, it means so much more to me now than it did. And I'm assuming that that's because I have a little bit more familiarity with the context, and I have a little bit more awareness of what things mean that I didn't really have meaning for earlier. So I hope I'm able to convey a little bit of the significance of what we're doing, because I think it is incredibly important. I would love to hear from you. I'd like to hear from you in yesterday's program. We did a review of Federalist number 78 yesterday, and at the end of our program we completed Federalist number 79, which is, as I mentioned, the briefest and probably most direct and easy to understand of the Federalist Papers. At least in my opinion it is that, and number 1. But even in Federalist number 1, written by Hamilton, the introduction to the Federalist, there's more in it. We spent some time on that earlier in an earlier program. There's a little bit more to that than meets the eye. But in this particular case, I think Federalist number 79 is probably the least controversial, or one of the least controversial papers. But even so, it contains an awful lot of important insights. And so what I'd like to do in our abbreviated program today is quickly review the essence of Federalist number 79 and then move into Federalist number 80, and in a future program, maybe the beginning of next week, Federalist number 81, and then we can actually get into Federalist number 82 a little bit, which deals with the breakdown between the federal responsibilities in the judiciary and the states. We would love to hear from you. If you have concerns or ideas or suggestions or questions or whatever, I'm not sure I would have the answer, but I do commit to the idea that I'll do everything I can do to find you an answer if indeed you have a question. And I'm guessing that our other listeners would appreciate hearing from you as well. Our phone number is area code 304-663-4676. That's area code 304-663-HORN, H-O-R-N, 4676. If you'd like to communicate directly with me one-on-one via email, my email address, waobrien906@gmail.com. That's W-A-O'Brien, O-B-R-I-E-N, small letters, no apostrophes, all one word, waobrien906@gmail.com. I think that, just to go back and touch on something I mentioned a moment ago, I really believe that one of the most significant issues that we touched upon yesterday, and in fact, it is so significant that I really kind of made a mental note to open today's program by revisiting it. And that is Alexander Hamilton's position in Federalist number 78 on his vision for the courts as serving as the protector for the minority, for minority rights. By itself, in a vacuum, on the surface, just looking at the language, ignoring history, ignoring historical context, and ignoring all the rest of it, one would say in a Republican government, of course we must protect minority rights. Because since we rely so heavily on majority rule, on majority votes, and all the rest of it, one of the priorities of our republic is that while we operate around the principle of majority rule, we are committed to the idea of protecting the rights of minorities. Because as we know, whenever you have a vote, you acknowledge the majority, but you also must recognize that there's a minority. And in a close vote, the minority is fairly significant. In other words, if there's barely a majority, then that means there's almost a majority within the minority. So the minority is very important. And protecting the rights of minorities is very important. And it especially applies in terms of the credibility of the system of justice itself. If you expect those who end up in the majority on the short end of a particular issue or a particular vote, if you anticipate and expect and assume that those people are going to continue to rely on and have faith in the system and the justice that that system provides, then you must not only protect the rights of the majority, but you also must be aware or be conscious to respect the input of the minority and respect the importance of the minority and respect the legitimacy of the minority position. It doesn't mean that you're going to create consensus, because as we know, consensus is, in most cases is impossible to achieve. But what you can hope for is that even if you are on the losing end on a particular issue, if you can acknowledge that the system was fair and that you were listened to and that your position was legitimately and seriously considered, then even though you lost the particular vote on a particular issue, you can remain a champion for the justice and the fairness of the system. In a popular government, in a republic, that is critical. That's a key element of the idea of virtue. The idea of virtue is not only knowing how to win, but how to lose. And how to do it in a way where you don't turn on the unfairness of, assume that the system is unfair, rather you respect the fairness of the system and the fairness of your opponents. On the surface, in the ideal, in the abstract, when we talk about protecting the rights of minorities, that's what surfaces, that's what comes to the fore. However, if you build in historical context into this story, in other words, if you take Hamilton's concern for the protection of minority rights and you look at it in the context of the discussion about minority rights during the period we're talking about, which is the debate over the Constitution of the United States, then the issue of minority rights at that time had a very specific, a very considered, a very meaningful meaning. At that time, concern for minority rights within the context of America's Republican environment meant the protection of property. It meant the protection of the wealthy. And it meant the continued priority of property rights within the entire political context of the Republic itself. You'll remember that in his famous Vices of the American Political System that James Madison put together in April of 1787, Madison listed the concerns that he had and other committed Federalists had, considered or committed nationalists had, about the need to strengthen the central government in order to take power away from the states and transfer it to the national level. And the reason for that concern was that as long as power remained at the state level, and as long as legislatures continued to dominate state government on the state level, that meant that the branch of government closest to the people was all powerful. In most cases, there were no courts. There was no judicial review. There was no Supreme Court. There was no president that could veto a particular piece of state legislation. In other words, once a particular piece of legislation passed the state legislature, it was law. And in that kind of a context, minority-majority concerns became real serious concerns, especially for the wealthy. Hamilton at the Constitutional Convention laid it out very clearly when he said that all communities divide themselves into the few and the many. The few are the rich and well-born, the many are the masses of the people. If you start deciding issues on a straight majority vote in the state republics, then the propertied are in trouble. Those who we would label as creditors are in trouble. Because as never before or since in American society, it was possible under the Articles of Confederation for people to demand state assistance, government assistance, and get it by majority vote through their elected representatives in the legislatures. Consequently, when Hamilton in Federalist number 78 is talking about the court's role in protecting the rights of minorities, that's what he's talking about. And when we touched on this yesterday, it occurred to me on the spot, then when we start talking about our nation as being a nation governed by the rule of law, a nation committed to the ideas of justice and fairness, it's very obvious that this is the key within a Republican context to protecting the rights of minorities. There needs to be general consensus or general agreement that there are certain things you can do and certain things you don't do, majority or no majority. You do not, for example, flagrantly interfere with the sanctity of private contracts and private agreements. You don't allow government to do that. And Hamilton realized that the only branch of government that could be relied on to stand up for those principles, for those absolutes, if you will, was the court. Which means that the independence of the court and the independence of the judges who sit on the court, in terms of their ability to not be cowed or not be swayed by concern about their jobs or concern about their salaries or concern about being reelected and all of these other things. Somehow you have to find a way, Hamilton recognized, to shield these people so that they could end up taking what turn out to be some very unpopular positions in their role as judges. They are the ones who have to define and apply the rule of law. They are the ones who have to tell the citizenry at large that this is a particular thing we don't do here in this nation. It's not just an issue of majority power or majority right. And that's really the basis of the Republic. And in number 78, Hamilton is assigning the role, the chief role, for protecting those minority rights to the court. He makes the point that the people themselves, even though the legislative branch is supreme in a republic, the people themselves, even though government functions according to the idea of consent of the governed. Once fundamental law is established, once the Constitution is ratified, it's up to the courts to make sure that it prevails. Consequently, it's up to the courts to stand up against demagogues and those people who would be able to successfully persuade large numbers of people to jump on board on a particular issue that seems fashionable or seems right at the moment. In other words, it's at that point when the minority of the people want to go in one direction and the courts realize, the judges realize, that we shouldn't go there because it violates our definition, our idea of justice. Somebody has to stand up to the people and say, even though as the people you have the right to change fundamental law, the reality is until that law is changed, you must obey it even though you are part of a majority. That's the idea of the rule of law in a republic. And it's to the courts that Hamilton assigns that principal responsibility. The significance of that principle is never really appreciated, it seems to me. I've heard people for years talk about the importance of Federalist number 78. And it always comes back to the issue of judicial review. 78 is important because it establishes the principle of judicial review. The fact of the matter is, in the last couple of programs, we've actually read that document. And the conclusion that we must adopt, must reach, is that Federalist number 78 does not establish the principle of judicial review at all. What it does instead is challenge the idea that judicial review means judicial supremacy. So consequently, what Hamilton is saying in Federalist number 78 does not contradict the idea of legislative supremacy. In fact, what Hamilton is laying out as the role of the court depends absolutely on the idea of legislative supremacy. That the will of the people, depending on the circumstance, must take precedence. And when it comes down to a contradiction between the majority of the people and the Constitution, fundamental law, it's up to the courts to come to the defense of fundamental law, because it always must take precedence over statute law, over man-made law. I think that principle, this whole issue of the role of the court as the key ingredient in protecting the idea of rule of law and justice within a republic that is susceptible to majority will and the rule of the majority of the people is critical and underappreciated. I think Hamilton's role in laying this out is underappreciated. Consequently, what we are left with as we transition from Federalist number 78 into number 79 is the fact that given the role that Hamilton has defined for the justices of the court, for the court itself, then the principle of lifetime appointments and a salary that cannot be diminished become the basis for the independence of the judges. And given the difficult task that's been laid out for them, the one thing they need to be able to rely on is independence. They need to know that they can't be voted out, or they can't be kicked out, or their salaries can't be reduced, or any other kind of political or economic pressure that can be put upon them because the position they're taking is not popular. Consequently, Federalist number 79, even though it's short, even though it's direct, even though it's not that controversial, is critically important. Because in that particular paper, Hamilton makes two principal points, two major objectives. The first one is the salary of the judges. The second one is removal of the judges. Hamilton even goes so far as to oppose the idea of age limits for members serving on the Supreme Court, on the courts. Not just the Supreme Court, but also the so-called inferior federal courts that Congress chooses to create. Once you are appointed, you hold your position for life. You can be removed through impeachment, but that's for malfeasance. That's for violation of the law, a violation of your oath of office. But the idea that you've become so old that you need to be replaced because you've passed the magic age of whatever it happens to be, in New York's Constitution at the time, 60 years old was the cap for members of the judiciary in the state constitution. Hamilton makes the point that that is inefficient, it's insulting, and it's absurd. Because, as he makes the point, we all know people who have well past the age of 60 years old, whose mind still functions like a trap, who remain sharp and creative and insightful and visionary. And Hamilton makes the point that in the aging process, it usually happens that people deteriorate physically before they deteriorate mentally. And to basically send somebody out to pasture because they have reached the magic age of 60, to Hamilton, is rather absurd. Because what you're doing is losing all of the expertise and all of the skill and all of the talent and all of the knowledge of the law that this particular judge has, merely because he's reached the age of 60 years old. And I'm saying he because at that time there was never even a consideration that there would be a female justice or a female judge on the courts. As we know, that has changed. So consequently, Federalist number 79 involves Hamilton's argument against the idea of arbitrarily capping service on the court due to age, and instead urges flexibility and urges the idea of judging each case on its own individual merits as it comes up. The other thing that Hamilton addresses in 60 is salary. And he makes the point that the Constitution of the United States specifically states that no judge's salary can be diminished while he sits, while he is in office. The salary can be increased, but it can't be diminished. And that makes it different than the president, because the president's salary can be raised or lowered. Because as we know, the president is elected. The president's political standing depends on the electorate. But given the role that Hamilton has laid out for the courts, you can't have judges vulnerable to the issues of politics, the vagaries of politics. So consequently, Hamilton in 79 emphasizes and reinforces and defends the convention's inclusion of the principle that a judge's salary while he sits in office cannot be diminished, ever. I don't think, and I'm just speaking from a personal perspective here, I don't think I personally, until we've reached this point right now, I don't believe that I personally understood well enough and appreciated the significance of judicial independence until this reading of Federalist number 78. I think it's very, very significant, however, and this is one additional point that came out yesterday and I wanted to reiterate. I think it's very significant that Hamilton does not emphasize this idea, this responsibility of the courts to take on the protection of minority rights. Because remember, Hamilton's job in the Federalist Papers is to convince voters in the state of New York to endorse the Constitution. If Hamilton made too much or was too explicit about the role of the court in protecting the rights of minorities, the rights of the wealthy, the rights of property, that by itself would have been enough to sink the Constitution. So therefore, Hamilton in number 78 has to be, not only in 78, but I think all the Federalist Papers are this way. By definition, they must be carefully crafted. They must be written in ways that are vague and not quite as definitive as they should be. And that's why it's so difficult for many people to understand them. Because in many cases they are abstract. They are evasive. They are filled with innuendo and assumption. They are written in ways which guarantee that only the few will really be able to understand the interior, the ingredients of what the issues are. And that's really what we're about here at the Virtual Center, is trying to understand those issues. I'll be honest, in what we've done with 78, Federalist number 78 in the last couple of programs, I feel much more comfortable in understanding why 78 is touted as one of the most significant Federalist Papers. I've pretty well convinced myself that it's a priority Federalist paper, along with number 10 and number 51 and number 39 and some of the others that get most of the attention. I think this is a critically important contribution to the Federalist Papers. I think 79, even though it's short, even though it's straightforward, even though it's not that controversial, it's critical because of 78, because of the charge that Hamilton lays out for the court in 78. Then the ingredients of 79 become critical. What I'd like to spend the rest of our time on today, and we have a little bit less than a half hour, I'd like to get into Federalist number 80. And we can pick up on this tomorrow and we can move beyond it into 81 as well. I had hoped that we could, by the end of this week, conclude with at least the judicial aspect of the Federalist Papers by looking at these major papers. It's beginning to look like we might not be able to do it. We might have to extend this into next week, but that's okay, because I really think that the subject itself is really what needs to drive our schedule, not the schedule. In other words, we need to make sure we keep our priorities in order. In Federalist number 80, Hamilton gets into the duties and the responsibilities and the objectives and the specific powers of the courts as laid out in Article 3 of the Constitution of the United States. Much of this focuses specifically on the document itself, on the Constitution. This morning, I kind of made a decision, which we probably should have done at the outset, is to actually look at the Constitution of the United States. Article 3 is the shortest of the three articles because Hamilton believed that the courts were the weakest and least significant and least to be concerned about branches of government. In point of fact, I think Federalist number 78 kind of contradicts that a little bit. But the fact of the matter is, I'd like to preface looking at Federalist number 80 by spending some time looking at the Constitution itself. In other words, let's look at Article 3 of the Constitution. It's the shortest. And at the same time, since it's the focus of these Federalist Papers, we ought to be familiar with it. So if you'll bear with me, and if you happen to have a copy of the Constitution of the United States, turn to Article 3 on the Judicial Department. Section 1, the Federal Courts. This is what the Constitution says. The judicial power belongs to the federal courts. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. There will be one Supreme Court, and then there will be a number of inferior courts which Congress will decide how many and where they'll be. In number 80, what Hamilton, and 81, what Hamilton is going to do is lay out the idea of circuit courts. District regions, dividing the nation into judicial regions and creating inferior courts. And then in I believe 81, Hamilton, we'll get to this either tomorrow or next Monday, Hamilton lays out exactly what the relationship will be between the Supreme Court and the inferior courts. But that's what the Constitution says. Under Section 2, the jurisdiction of the federal courts. This is the kind of cases that the federal courts will be able to hear. And this is what the Constitution says. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. let me stop and just make one comment. Arising under this Constitution, the laws of the United States and the treaties made. In other words, the federal courts will have jurisdiction in cases arising under the Constitution and under the laws of the United States. What's the difference? Well, the first one, arising under the Constitution, would mean that if a particular issue is directly related to something in the Constitution, by definition, it becomes a federal court matter. But also, if the issue in question arises under the laws of the United States, think about that. The laws of the United States are the laws passed in conformity to the Constitution. So in other words, you have a couple of steps removed here. This gives the federal courts broad jurisdiction, it seems to me. And let me point out one further thing. If the federal courts are going to hear cases arising under the Constitution and under the laws of the United States, then obviously it must be the courts themselves that determine whether in fact the issue at hand is connected to the Constitution or to the laws of the states. By definition, by inference then, judicial review is implied. The implication here is the courts are always weighing the laws being passed against the fundamental law, which is what Hamilton says they must do in number 78. So that's the idea of judicial review being implied or assumed here. If the courts are going to carry out the powers that the Constitution specifically gives them, then they are going to have to exercise the idea of judicial review in order to make the determination whether in fact the issue is theirs or not. So I think that's pretty significant. As well as all cases arising under treaties made or which shall be made under their authority, under the Constitution or under the laws of the United States. To all cases affecting ambassadors, other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens or subjects. So the court's range of interest here is broad. In most cases, as we'll see, the court's jurisdiction is going to be, I'm stuck for the legal term. It's going to be an appellant. In other words, it's going to be by appeal. The case will be decided at a lower level, and if it touches one of these areas, it will be by an inferior federal court. But the appeal can be made to the Supreme Court. So most of the court's roles is going to be an appellate role. So that gives us the kind of idea of the range of cases that the courts will hear. The second part, number 2 of Section 2, deals with the jurisdiction of the Supreme Court. In all cases affecting ambassadors, other public ministers and councils, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In other words, if it involves a foreign country, or ambassadors of foreign countries, or councils of foreign countries, or whatever, it's a direct Supreme Court issue. In those cases, the Supreme Court, will have original jurisdiction. The case will go immediately to it. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. So what we're saying here is that the vast majority of the Supreme Court's business is going to be appellate. In other words, the court is going to be hearing cases that have already been decided somewhere else. And the litigant, or the losing side, appeals the decision to the next level. And of course, the Supreme Court is the highest level. And then the third part of Section 2 is trial by jury. The trial of all crimes, except in cases of impeachment, shall be by jury. And such trials shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. We know now, for example, that just this week, the Boston Marathon Court case has begun. And the courts are looking at 1,200 prospective jurors because they recognize that the publicity surrounding this case is going to make it very difficult to seat a jury. So the pool of potential jurors is very large. Even so, it is anticipated that the case itself may not begin to be heard until the marathon in 2015, which will be April 19th, which will be 2 years after the bombing. You may also be aware that the lawyers for the defendant, Tsarnaev, have requested a change in venue, have requested that the case be removed out of Boston because the thinking is that Tsarnaev cannot receive a fair trial in that area because the case receives such publicity and such attention. And the judge denied that request. And part of the reason for denying the request deals with the reality that the marathon case bombing received such attention that there's really no place that you could move the case where it wouldn't be something that people knew all about and had already formed opinions on. That's Article 3 of the Constitution. That's it. Basically, what kind of issues the courts are going to deal with, the jurisdiction of the Supreme Court, the principles or the issues on which the courts will involve themselves, and then the issue of trial by jury. Hamilton writes 5 Federalist Papers to address Article 3. So while it is the shortest article in the Constitution, it is a very, very significant one. Number 80. In number 80, Hamilton opens by saying that in order to judge the accuracy of the proper extent of federal judicature, it will be necessary to consider in the first place what are its proper objects. In other words, what kinds of cases will the court hear? And of course, Hamilton takes this right from the Supreme Court. He says, it seems scarcely to admit of controversy that the judiciary authority of the Union ought to extend to these several descriptions of cases. And then he lists 6 specific kinds of cases that the federal courts will be involved in. First, to all those cases which arise out of the laws of the United States, passed in pursuance of their just and constitutional powers of legislation. All cases which arise out of the laws of the United States, whether it be the Constitution or whether it be the laws passed by the Congress or by the states that are in conformity with the Constitution. And of course we know that it's going to be the court, the federal judiciary, the Supreme Court, that's going to make that determination when charges of unconstitutionality are raised. So that's the first area, the first kind of cases. Second, all cases to all those which concern the execution of the provisions expressly contained in the Articles of Union. The Articles of Union, of course, is the Constitution. So all cases which concern the execution of the provisions expressly contained in the Constitution. Third, all those in which the United States are a party. Not any one state, but all the states. Fourth, all those cases which involve the peace of the Confederacy, whether they relate to the intercourse between the United States and foreign nations or to that between the states themselves. Whenever the issue addresses the peace of the Confederacy, whether it's between the United States and a foreign nation, whether it's between a state and a foreign nation, or whether it's between 2 or more states, the mere fact that it involves more than one means it becomes a federal issue. And the federal courts have the authority to decide. Fifth, all those cases which originate on the high seas and are of admiralty or maritime jurisdiction. And lastly, all those cases in which the state tribunals cannot be supposed to be impartial or unbiased. If the case involves another state or the citizens of another state or more than one other state or a different nation or whatever, then by definition the assumption is that the state's courts would be biased and only the federal courts would be able to keep the kind of national perspective that would make a fair, unbiased decision possible. In other words, the role of the federal courts is to deal with the peace and tranquility of the United States, and anything that potentially disrupts that, the unfair treatment of citizens by another state, the unfair treatment of one state by another, the unfair treatment of another nation by a state or by more than one state, all of those things would be federal issues. And then in number 80, Hamilton addresses each of those 6 and explains in detail what they involve and why it's important that the federal courts deal with them. and I'm kind of moving quickly here because we're coming to the end of our time. We have about 2 minutes left in today's program. So what I want to do is just kind of scope out the overall outline of 80, and then when we get to tomorrow's program, we can go into the details of it. So what Hamilton opens number 80 by doing is laying out the 6 areas of cases where the federal courts will be involved. Then what he does is quote the Constitution after he finishes addressing each of those 6. Then he addresses the Constitution itself, where the Constitution in Article 3 spells out exactly the principles which ought to regulate the constitution of the federal judiciary. In other words, what are the principles or the particular powers which the convention intended the federal courts to address? And there, that whole section of the Constitution, Article 3, is quoted in Federalist number 80. It is to comprehend all cases in law and equity arising under the Constitution, the laws of the United States, the treaties made, or law and equity arising which shall be made under their authority, etc., etc., etc. And then Federal number 80 closes by looking at each of the specific issues in the Constitution which require federal court involvement. And that's really the structure of Federalist number 80. In other words, what Hamilton has done is lay out the scope in 78 of what the role of the courts is in relationship to the Constitution. Then in 79, he has established the importance of the independence of the judges so that they can do that. And then in number 80, he's laying out the cases, the kinds of cases that the federal courts will hear. And then later on, he's going to go into the distinction between the cases the federal courts hear and the cases the states courts hear, and why you can't mix them. And then finally, he's going to address the very last section of Article 3 of the Constitution, which is the issue of trial by jury. That's our agenda. That's where we'll be going, and I invite you to join us. We'll be back tomorrow here at the Virtual Center for the Study of the Constitution and Civic Responsibility. We are at the end of today's program. It is 59 minutes after. Again, we have a very, very cold couple of days in store. Please be safe. Please be careful. Please prepare and take care of yourself. But more important, check on those who may have trouble taking care of themselves. And we can get all of us through this. This is Bill O'Brien. Thank you so much for tuning in. I look forward tomorrow. We'll be back at our regular time, 1 p.m. in the East, for a 2-hour program. This is Bill O'Brien. Thank you so much. Have a great day and be safe.